Foreign domiciled applicants may want to know, can a foreign company register a U.S. trademark? The U.S. market is highly saturated, which makes introducing a new product or service really difficult. Although achieving registration for a U.S. trademark through Madrid Protocol is possible for a foreign applicant, it is not necessarily more accessible when compared to filing directly at the USPTO with the assistance of a U.S. trademark attorney. A rule change at the USPTO requires a U.S. licensed attorney's representation for foreign companies or individuals seeking U.S. federal trademark protection. The USPTO's introduction of the U.S. Counsel rule is an effort to curb fraudulent submissions. The rule applies to all filings, including new applications, renewals, assignments, office actions responses, and even minor changes such as a change of address. Additionally, the rule aims to improve the accuracy of submissions because of inadequate or worse, unauthorized practice of law. A competent trademark registration process probably looks eerily similar to your home countries. A comprehensive trademark search. A trademark application process is not getting off on the right foot if the applicant is not crossing their T's and dotting their I's. This involves conducting a thorough trademark search with the assistance of a U.S. trademark attorney. That includes conducting a search across the board with the registered marks in the USPTO's database and common law marks that might exist that you might not necessarily know of in your initial search. A trademark search helps avoid conflict with previously registered similar marks. Additionally, it provides flexibility to the applicant regarding their unique brand name or logo. Maybe your US trademark or branding will not necessarily look similar to the one in your home country because H&M is not H&M in Germany. If a thorough search through the Trademark Electronic Search System and a comprehensive search using a third-party search service reveals no issues, the application is ready to file. But more often than not, foreign domiciled applicants will find a mark that is too close to comfort, and the best case scenario is that you would need minor tweaks for your brand's reputation in the US. This is where the assistance of a US attorney will ensure that your marks are enforceable under US trademark law and avoid litigation involving trademark infringement. To file for a US trademark, you need to use the Trademark Electronic Application System. It's the USPTO's filing system. Your filing date is usually your priority date. The system allows a foreign applicant to describe the appropriate classes of goods and services their mark will be associated with. U.S. trademark law requires a bona fide intent to use for all marks to be registered at the USPTO. The U.S. Trademark Application System recognizes multiple filing bases, and we've discussed these before. The 1A in-use filing basis, which is applied for when the mark is already in use to offer the associated goods and services. All applicants must show evidence of use at the time of filing. Evidence includes product packaging, labeling, for some it's websites, for some it's invoices, for some it's a t-shirt because they're selling t-shirts and all you need to show is the back of your tag. Next kind of filing basis is an intent to use filing basis. Usually applies when your mark is not necessarily currently in use, but you intend to launch it in the near future. And an intent to use filing will not receive registration without proof of use in commerce. A foreign registration, 44E, usually expedites the U.S. application process. Additionally, foreign applicants can base their U.S. trademark application on the existing registration. Another kind of filing basis is the foreign application filing basis, the 44D, an excellent strategy for foreign trademark filings that want to utilize their priority date as established in their home country. Although you can only use this filing basis if the foreign applicant files within 6 months of the home country's filing. The different filing bases and their benefits are covered in a previous video and blog. Let's talk about the post-application process. Feel free to review the current processing times for all new applications in a link I'll provide you below. The USPTO provides their updated guidelines. But let me just tell you, you're probably going to be waiting for about 10 months. It is essential to ensure that the application was filed correctly. An incorrectly filed application will cause unnecessary delays in the registration process. A USPTO application experience is not complete without an office action. This is usually an argumentative or a non-argumentative communication from the examining attorney at the USPTO. In December 2022, the USPTO introduced a rule change in the response time required for an office action. They stated that now applicants must respond to an office action within 3 months, unlike the older 6-month deadline. It is essential to address all questions the examining attorney raises before responding, as an incomplete or incorrect response might lead to final office action and possibly a final refusal. Registrability at the USPTO depends on many factors. But first and foremost, you must be able to describe your goods and services, and they must fall under at least one of the 45 US trademark classes. This means your application's description of goods and services must include goods or services you are actually selling or intend to use in the future if you're filing a 1B application, which is similar to the Madrid Protocol application process for a US trademark, where they don't necessarily require proof, although unlike the Madrid Protocol, a 1B application of the USPTO will eventually require proof of the mark being used in commerce. You've done all the work, you fought the good fight, you argued against those office actions, and now you're at trademark registration. If successful, your trademark will be published in the official Trademark Gazette, where third parties have the option to oppose your mark's registration. Trademark Gazette is the USPTO's official trademark bulletin. An opposition proceeding is usually filed because a company or individual believes your mark will likely confuse and dilute their prior registered mark. Opposition proceedings are initiated at the Trademark Trial and Appeal Board, the TTAB. Successful registration will come with a trademark registration certificate and the enforceable rights that come along with it. A US trademark lawyer will also assist you in maintaining your trademark registration at the USPTO. The registration comes with maintenance filings that must be filed in a timely manner to keep the registrations active. These filings aim to restrict monopolistic behavior, which requires continued use of marks in commerce. Consulting with a licensed US trademark lawyer is essential for a foreign entity or individual, essentially one who understands the nuances of different filing bases for foreign domiciled applicants. If you or your client needs the assistance of a licensed trademark attorney, please reach out by clicking the booking link provided in the description below. As always, this is Sal Malhotra. Thank you for watching.